So next we actually have Jonathan returning, which is great to join the panel. And we have
back to back Jonathan. How can you go wrong? Right? That's worth the price of admission right there.
Sure is. And we have our associate lawyer Golan joining us as well. Welcome, Golan.
Good afternoon, Golan.
Yes, hi there. Hi everyone. Thank you for having me.
Right. So I'm going to start off by, I don't want to take up too much time. I want to leave as much time as we can for our speakers, but I just wanted to let you know what's on the agenda today. So as I mentioned, we have Jonathan Painter returning, who joined us for the divorce and domestic violence presentation. Thank you, Jonathan. And we have Golan, an associate lawyer and mediator at our firm. With today's discussion, they will be talking about what is the Voice of the Child report, who prepares the Voice of the Child report, private versus OCL and judicial interviews. They will discuss the how, the weight, the treatment by counsel, parents, and judges, screening, the child's right to counsel, challenging Voice of the Child reports. And they will share some cases on the topic. And finally, they will also try to reserve some time for questions as well from the audience. So again, you can send those through the Q&A. We encourage you to do so, and we'll try and make time to answer those. So I just want to give a brief background on Golan before I pass things over. So Golan has 25 years of legal experience. He was first called to the bar in Israel in 1996, and then called to the bar in Ontario in 2003. Golan has extensive experience in representing clients and negotiation agreements, as well as trial work. He also has experience in negotiating with the authorities to advance a client's interests and has represented clients at various levels of court, including on appeals. Thanks, Golan, for joining us. And now I will pass things over to Russ to get started with the presentation.
Golan, what is the Voice of the Child? You know, this came, it seemed like a couple of years ago, the judges had a conference and this was the flavor of the day. Everybody wanted, all the judges wanted Voice of the Child. What is this? What are we talking about?
Firstly, thank you for having me here. It's a pleasure. And to jump right into it, I agree with you that it became not a trend, but it's really the past several decades that this thing have developed following the UN Convention on the Right of the Child and the attempt to get the views of children, realizing that they need to be heard in their process. It's affecting them in many ways. So the report's supposed to be giving a straight, without evaluation, idea of what are the views and preferences of a child with respect to the various outstanding issues, which is normally the parenting arrangements and in the ancillary issues that we're dealing with every day in every file that concerning children. So that's in a nutshell what we're expecting to receive from the report, that we can, like I said, it's non-evaluative in a way, but some do give their recommendation. I mean, some of the reports you find later on that are including recommendations, for example, from the Office of the Children's Lawyer, but generally speaking, they're not supposed to be including any recommendations or any evaluation of authenticity or you know, how genuine and uninfluenced the child is. But that's the gist of it. Okay, so the framework for obtaining the Voice of the Child report, we can look at the Section 30 of the Children Law Reform Act that provides the availability of obtaining a report to evaluate the needs of the of a child. You can see that in this area, there is a need for a technical, professional, skilled assessor to provide that assessment to the court, and this has to do with the needs of the child. If you can go to the next slide, you would see the investigation that is under Section 112, which is the mandate to the Office of the Children's Lawyer to conduct their investigation once they accepted the appointment and accepted a case for investigation, and a clinician is normally engaged to provide the details of what would be in the best interest of the child. One of the areas that they can obtain information, if you look at the sub-paragraph C, you will see that they can meet the child and get the views and preferences in that respect, and to include also recommendations when they give their reports at the end of the day. If you can go to the next slide, you can see that all of that is an implementation of the Article 12 of the United Nations Convention on the Right of the Child. It has been implemented in many provinces differently in terms of how it's going to be obtained, and the fact that the child has to be included in the process, not only when it gets to the trial phase, but rather they need to be obtaining their views and preferences throughout the ordeal of following separation, and they should be entitled to their to be heard in the process. Part of the implementation is the sections that we just talked about earlier in the Children's Law Reform Act, and in the basically in the Children's Law Reform Act regarding the process of how to obtain the voice of the child. That's the legislation framework under which we are operating when we're trying to get this evidence or get this information from a child.
That's good to know, because sometimes when you're in court, we've got a poll question, we'll give everybody a chance to answer it. How often is the voice of the child report obtained? Real quick, is that section 30, 112, both, either? Jonathan, you see them come in both ways?
Yeah, for sure. Yeah, if they're going through the Office of the Children's Lawyer, it would be a section 112. And if it's coming through the regular court system without like going to a private assessor, I should say, then it would be section 30. And sometimes I do them out of court as well. It's very common for me to do them when I'm doing family mediation cases or collaborative cases as well.
I was just going to say, you don't have to go to court. You can arrange for a private voice of the child assessment, which is great, because now you don't have to wait for, a case conference or motion and then the OCL to reply. It could be 3-4 months down the road before anything substantive happens. If you do it privately, you can turn it around in a week or two, depending on everybody's schedules. So something to keep in mind. All right, so let's see what our audience is thinking in terms of how often a voice of the child report is obtained. Clear majority in every case when it's ordered in the Office of the Children's Lawyer accepts the appointment or orders that the parents retain a professional, is 77%. In every case when the judge orders it, well, that may not be so. We'll tell you why. 17%. And in every case when one of the parents is asking for it, 4% and then 2%. Is there a correct answer here, Jonathan?
No, there's no correct answer. Most of the time the judge will recommend it for older kids, but sometimes it's the parents that request it, sometimes it's the lawyers that request it. I've had a rare situation where a child has actually requested it. So yeah, it can come through the system in a lot of different ways.
But it's not a clinical assessment. Will the OCL say, no, we're not doing it, we don't have the resources? Or do they take everyone?
Sometimes, yeah, because they can only take so many cases a year, because they have limited resources. So sometimes one will get referred to them and they won't accept the case, which is really tough on the parents who are hoping to get it through. And it causes a delay in the process because, they have a bureaucratic system to assess whether they're going to accept or decline cases. So it can be a few weeks of waiting time to hear back from them, which can be frustrating for families.
No discourtesy to the authorities, but it seems kind of random, right? You're throwing it at the dartboard. It maybe you
I haven't figured out a system yet. Yeah,
there's no science behind it. It's not like you got a grid and you can know, okay, this will pass or that won't. But okay, so let's talk about who prepares the voice of the child report. Jonathan?
So typically it would be a mental health professional like myself who has experience both working with kids and working in the family court system or the family law system in some way. They might be a mediator, they might be a social worker, they might be a psychologist, but they have to have that two sides of their experience, one in the family court system or family law in general, and one as a mental health professional who works with kids. I wouldn't recommend just anybody for these kinds of reports because there is quite a high level of expert knowledge that you need to have in order to do these things, like knowledge about child development, knowledge about family systems theory. You want to know about family law and what family law is all about. Yeah, so what I would recommend you do is find a professional who has a long time working in the family law system, that they have specific training to work with kids. There are courses that you can take. The Ontario Association for Family Mediation offers a child inclusive mediation course, for example, for family mediators who want to learn how to interview kids and how to prepare reports for the voice of the child processes. So yeah, that's generally it. There are a few lawyers who do this as well. And again, they would have a lot of experience working in the family court system, but you would also want them to have some training on interviewing kids, because kids see and perceive the world in a very different way that adults do. And knowing that is really important when you're interviewing kids, because kids are much more susceptible to, say, leading questions, right? If you ask a child a question, it might create a false memory for them. For example, if you repeatedly ask them, "Are you safe with your father? Are you safe with your father? Are you sure you're safe with your father?" They're going to start feeling like maybe they're not safe with their father, even if they are. So knowing child interviewing techniques is really, really important. And you have to know not to ask leading questions during the process as well. So you want to make sure someone has that experience and training.
All right, so let's go to our audience. Let's ask another poll question, see where everybody's head's at. How much would the voice of the child report cost? So we're going to thank you again for being here today to our audience. We're going to give you a few minutes to answer that poll question, but without naming names, we have a few comments coming in. One's talking about getting a voice of the child without going through the OCL. That's the most efficient way to do it if your clients can afford it. Another audience member said of the 20 they've applied for, they've only had 2 accepted. That's terrible. Sorry to hear that. Another one, we have a question about accreditation. On the agenda, it tells you what it's accredited for, but Shannon, maybe you can put in the box whether the previous presentation was accredited. Paula's was not applied for, if that's what you're talking about, but the previous one I believe was. A question came in: if you can anticipate the OCL agent is going to flag undue influence, what's the best way to preempt this? I'm not sure if I follow that question. Do you know what they're talking about, Jonathan?
I think my guess is that they're talking about undue influence of a parent.
Right.
So this would probably relate to what a lot of people call parent alienation cases, where one parent is influencing what the child says during the voice of the child process. That is something you want to watch out for as an assessor doing these reports. There are certain tricks of the trade that you can use to find out if a child is being influenced, but ultimately there's no really surefire way of 100% making sure that they're not being influenced. But we would look at things, for example, like if they're saying things in a way that a child their age wouldn't normally say. So you've got an 8-year-old saying, "Well, I'd really like a week about schedule, and I'd like the exchanges to be at 7 p.m. on Fridays."
No, the 8-year-old saying,
normal 8-year-old's going to talk that way, so you know that's coming from a parent.
The
right?
8-year-old saying, "I want 15 days with dad."
I want 50, yeah, I want 15 out of 30 days, so that dad doesn't have to pay child support. Yeah, that's a
It's
good,
sad. It's so sad, but we hear that, right?
Right. Actually,
Yeah.
on that, I have an anecdote that one of a client that was, I mean, a child that was being interviewed. So you're talking about the trick of the trade. So how do you still flag an influence? So the kid was wearing a shirt with the number one dad on it. So so obviously, I mean, you can describe the room that you were in, but the assessor found it necessary, of course, to say, this is I'm interviewing this child, and this is what he's wearing at the dad's place when I'm interviewing him. So, you know, sometimes you read between the lines, like you said, you don't have to say to a judge, I think he was influenced because he's asking for a week about the parenting schedule. But generally speaking, we're not supposed to be receiving that evaluation or, you know, evaluative type reports. And I think judges are, you know, I think they're smart enough to read between the line when they read the report and see, especially if it comes back verbatim in terms of exactly how the child was responding, as opposed to rephrasing what was said. And then you can really,
a really great point, Golan. And when you're preparing the reports, it's really good to put in actual quotes that the children said. So I try to record as many quotes accurately on my notes, so that I can specify how this child was talking. So that's a really great point.
Back in the day when I used to go to criminal court, I saw the number one dad t-shirt on a guy who was going in to be sentenced. And I think he was looking for some leniency, but let's see what our audience thinks of this poll. And then while we're looking through those results, I just want to plug some recent donations that came in. Say thank you to Rose, Udoka, Emmanuel, Shannon. Thank you everybody for your donations to the center. Okay, no cost is done through the OCL, 48%. Both parties share it's 50-50, 27. Proportionate, 17%. Depends on how many children are. That's interesting. If the children's going to gear the costs, 33%. 3 to 10, depending on jurisdiction. Judge decides by whom and how much. Well, I think it's through the OCL. Nobody pays. Is that right, Jonathan?
That's correct. Yeah, the OCL is publicly funded through taxpayer money. So there's no charge for those ones.
And if it's
then
private, you can, sorry, go ahead.
Yeah, I was just going to say, you kind of anticipated my next comment. Yeah, if it's private, it depends on how much the practitioner charges, and different professionals in different jurisdictions will charge different things. So it really depends.
Depends on the resources of each family member. But let's not steal your thunder. Next is private versus OCL and the judicial system. So maybe you can take the lead on that one, Jonathan.
Yeah, so, you know, the OCL does quite a bit of this kind of work, but if your case is rejected by them, or if you want things to go a little bit more quickly, then you can always hire a private person, someone with a similar background to myself who can do them. And my turnaround time for Voice of the Child is pretty short. It's usually 2 to 3 weeks. Whereas if you're asking for a bigger, you know, parenting assessment, like a full section 30, that usually takes several months to complete. So it's a quicker process. And the court will usually have some go-to people that they will refer to, or, you know, I'm sure both you and Golan have some go-to people that you like to refer to as well. So it's good to have a list of names that you know, professionals that you trust, that you've seen their work, that you have confidence in their ability to provide you with a good Voice of the Child report.
The go-to for me is whoever can do it, right? You guys are busy and the schedules. So whoever can,
was the first person available,
accommodate your schedule, you know, and if you can move the lineup from 2-month wait to next week, and the person's qualified, that would be my recommendation. There was a question about the domestic violence that was accredited for 1 hour of professionalism content by the Law Society. If you attend both days, today and tomorrow, and you're a lawyer, you get all the credits that you need for the year for your CPD for free. All right, amazing. The how do we do this, Jonathan? How do we go about, what are the mechanics behind the Voice of a Child report?
Yeah, so there's no like hard and fast rule about exactly what you have to do. So every professional kind of comes up with their own process. My process would start with an intake appointment with each parent. Obviously this is after receiving the referral from either the lawyers or from the court. And then so I'll meet individually with each parent to do their intake. And then I'll usually have a minimum of 2 sessions with the child, one when they're brought in by their one parent and the other when they're brought in by their other parent. And the idea for that is to get some balance, right? If you sense that the child's responses are very different depending on the parent that they are brought in by, then that will give you some idea that there is some parental influence. So I usually have a minimum of 2 sessions with the child. And then what I'll do is I'll write up my report. And then I'll often have a 3rd session with the child just to go through with what my comments are going to be and what they consent and what they don't consent to include in the court. So there's no age of consent in Ontario, but it's really, really important in this process that you get the child's consent. Even if they're 9 or 10 years old, you want to explain the process to them and make sure that they're okay with you sharing the information that they share with you, because you can do potentially more harm by sharing something with the court that the child doesn't want you to share. So once I've completed all the interviews, I'll write up a report. And every report will look slightly different depending on the professional who's doing it. But my process is to kind of explain the process at the beginning, talk about what the parents said, talk about what the children said, and I'll usually have some recommendations. Now, they're not recommendations about the parenting schedule or what should happen at court. But if a child's talking to me, for example, and they're really sad about what's going on with their parents and they're really upset about all the fighting they're being exposed to, sometimes I'll make a recommendation that the parents find that child a counselor to help them through that. Or if I suspect a child has a learning disability and is struggling in school, for example, I'll recommend the parents look into getting them a psychological assessment through the school to get them the extra help that they need. So like Golan said, the reports are intended not to be evaluative. So I'm not determining which parent's plan is the best or anything like that. I'm just really reporting on what the children are saying.
And it doesn't have to be written. I've had families in the collaborative process, teenage child, 14, 15, that particular case, both parents are reporting something different in terms of views and preferences. We got a voice of the child report. It was delivered orally in the meeting. Turned out child didn't want to be with mom, wanted to live with dad. Real punch in the stomach for mom, like, oh my God, hearing it. But they both respected the child's wishes and settled that case that day without having to get a written report, because they're both, ultimately they want was in the best of the child. And it saved time, it saved expense, and we didn't have to, put the child through any more misery of picking between mom and dad. So that was kind of an interesting take on, the speed of getting an oral report as opposed to a written report. I assume you can deliver it much faster, right, Jonathan?
Yeah, it's much faster. And it, like you said, it can be really impactful for the parents. And the intention of these reports is to get the true views of the child, because
Right.
what a dynamic that's often being set up and you described really nicely is that, the child will tell their dad what they think their dad wants to hear. They'll tell their mom what they think their mom wants to hear. So both parents feel empowered that they know exactly what the child wants.
Yeah.
But really their true thoughts and feelings aren't revealed because they're afraid of upsetting or disappointing one or both of their parents. So that's why a neutral, like an assessor, can be really valuable in those cases to kind of settle that debate. And if the child really does want to live with one or the other parent, it is very, very difficult for the parent to hear that. But hearing it from a neutral will be much more powerful than hearing it from the other parent.
And in a controlled setting, in a collaborative room with other professionals to support you, it's much better than in an open courtroom.
Absolutely.
during a
Yeah.
5-day trial. But Golan, I just want to throw this at you. Have you ever experienced judges directly obtaining the views and preference of the child? They can do judicial interviews, but have you had a case like that?
I have not seen or encountered a situation where a judge requested the child to come to chambers for an interview. I think with today's availability of professionals, whether it's the OCL or private ones, they definitely defer to these situations to obtain the report, and not, I did not see or experienced a situation where a judge was requesting to interview a child in the
Okay,
process.
Here's a hook for our audience. Keep the questions coming in. I really appreciate it. I did have a case where the judge ordered the children be brought to the court, and I'll let you know how that case worked out at the end of this. But one question that came in, are these ever contemplated for grandparent access? Which is interesting, right? Because we can make contact orders for non-parents who have an important role.
I actually, I can comment that, Ras.
But oftentimes grandparents are the only stable influence in the child's life. But go ahead, Golan.
Sorry to interrupt. It just, I happen to have a case that only the grandparents are involved, because the parents were basically not able to parent. So the grandparents are the one that looking after the child, and we actually obtained a voice of the child report from not the OCL, because we wanted to speed up the process, so we went privately, and that's so yes. So the answer is yes. It can be done also for the purpose of finding out the views and preferences when it comes to grandparents' access and contact. It's not it's not limited just to the parents. Again, you need to have a consent, or you need the judge to order that, and that can be done. It's not something that is so in this case it may be unusual that it happens, but it does happen.
Well, it makes sense. Why limit the child's views to just the parents?
Right.
Where they think of it the time with the grandparents, or maybe it's an uncle or another family member. I'm going to throw you guys in the hot seat here, and sorry to do this, but I want to be responsive to the audience's questions. Adam, the case law update earlier today, highlighted voice of the child reports who contain the reviewer's, quote, reservations to the child's opinion. Some experts are saying, including reservations, are, these observations or reservations in one of these reports is inappropriate. What do you guys say to that? You want to go first, Jonathan?
Sure. I know, for example, with the OCL, their policy is to never report reservations like that. They are just purely reporting exactly what the child said to them. And
unfiltered, here's what the child's saying. I'm not passing judgment on it.
Exactly. But other people, myself included, will provide an opinion on that if it's relevant. And I had one recently where the child was really upset with the level of treatment that she was receiving from both parents. And this is a very sad case for me, because I met with the girl around the time of Thanksgiving, and she had mentioned that instead of spending Thanksgiving with her family, she took her meal up to her room because she just can't stand all the conflict going on between her parents. So in that case, I did offer an opinion that the it came from the child, but really emphasized the fact that the conflict was having a very negative impact on this poor girl's mental health. So different professionals have different approaches. Some will be more likely to wade into that kind of opinion, and others will stay away from it. And for me, it just really depends on the circumstance. If it's appropriate, I'll do it. If it's not appropriate, I won't. And there are some things I will never comment on. I won't comment on a parenting schedule and what I think is the best one, because I'm not doing a full parenting plan assessment. But I will sometimes comment on, if the child was being influenced, or if the child needs counseling, those kinds of things. What's your experience, Golan?
Well, this ties in neatly with our next two topics. I can flip it over to Golan. Weight treatment by counsel parents and other judges. And I guess when we get into cross-examination, there's some
Right.
fodder there as well. So take it away, Golan.
Right. So it also connects to the comment that Jonathan just made. I find a reason to dispute a voice of the child report when there's too much assessment of the child's whether it's being genuine, whether his comments are consistent and something of that nature that basically gives a judge the idea that whatever this kid just said is 100% correct, and you should take it at face value without letting the assessment is prejudged already. And I sometimes find it problematic and not effective in the sense that it takes away from the judge's powers to truly evaluate and listen to the counter arguments, whether or not a kid may be manipulated, maybe had been manipulated, things like that could be weight differently. So we're talking about weight on such reports, and obviously it's at the end of the day it's the judge's discretion, and it's a factor in the overall decision that a judge would make respecting parenting or what's in the best interest of the child. So that's the comments of whether there has been undue influence and other things that could also be part of a full 112 report of assessment of best interest issues. But in terms of the voice of the child, it's just one piece in the puzzle that a judge can weigh in the overall assessment of what's of the best interest issue.
Yeah, and in terms of the parents, a lot of these cases settle when the report comes in, whether it's voice of the child or an assessment. The writing's on the wall. They may not want to spend another $30,000 or $50,000 having a hearing on the matter. That could be better spent on the child's education. But there's some people just want to fight. They don't care. The report can say anything. They're just going to fight regardless of what happens. So let's talk about the right to counsel. Adam talked a little bit about the COVID cases this morning, and we want to be mindful the child still has consent, the issue of consent when it comes to medical treatment. But what about the voice of the child and the right to counsel, and I guess in some sense the right of the child to be heard? What do you say about that, Golan?
Well, I think it ties up with the voice of the child, like you said, in terms of the right of a child to be able to obtain his own legal representation. In fact, when we're talking about the right to counsel, but that also part of the OCL mandate to provide that to a child from a public resources. In other situations, we can have it privately, right? Sometimes we can decide, or the parents can decide, or a judge may decide that the child should have his own independent representation, and if the means are there, then the parents may engage one. I think that's, and then counsel speaks on behalf of the child, that not necessarily just the views and preferences, but it may be advocating for the child's views in a much more effective way, than just providing a voice of the child report. And just on that, just to comment on that, in fact, through my review of some recent cases, I found an abduction case where a private lawyer was used to obtain the voice of the child. And despite the fact that the lawyer did not have extensive experience, in fact, experience at all in interviewing children, the judge did not reject the report. It actually looked at it and used it in the evidence ways whether or not the exception to the return of the child was applicable. And it was using that report, even though it did not come from an expert like Jonathan or other skilled professionals. So just to show that it's not limited, of course it is preferred because it would be given more weight. And like Jonathan said before, there's some things to be wary about, there's things that have to be careful. And if we want the report to be more effective, we want the questions to be asked properly, etc. So all of that is appropriate for, you know, for a professional to do. But there had been occasions where non-professionals conducted the interview and provided the report. I can provide the citation when we get to the case law on the topic. I can definitely add that on to the few cases that we're talking about.
I'm just looking at some of the audience questions here. I'm wondering if I'm threading the needle too thinly here, but maybe Jonathan could talk about this distinction. You got the voice of the child, so we're understanding what the child's views and preferences are, and then you have your involvement in making recommendations regarding parenting. Like, here's the parenting plan I recommend for this file. That's different than the voice of the child. Can you just briefly describe how those two are different? Because we're getting some audience questions on this.
Yeah, I saw that question. It's a good question. So when you're doing a voice of the child, your primary task is to report on what the child's views and preferences are on the parenting schedule or some other issue, you know, who they want to live with, where they want to go to school, whatever the issues in court are being discussed, you want to get the child's views on those issues. So that's why you, as an assessor doing a voice of the child, I wouldn't make recommendations about a parenting schedule, but I would report on what the child thinks of that parenting schedule, whether it's, you know, a week about or a 5-5-2-2 schedule, whatever it is. When I do a thorough full section 30 assessment, a parenting plan assessment, then my task is very different. And yes, it's to report on the voice of the child, but it's also to make recommendations about what I think, based on my experience and expertise and training, what I think would be in the child's best interests. Now, you know, depending on the age of the child, when you're doing a full section 30, the children's views and preferences should strongly influence your decision. But as we all know, sometimes kids don't want what's best for them. You know, my kids would love to stay up and eat candy all night and not go to school the next day. But as a parent, we have to make sure that you know, they are going to school and they're not just eating candy. So so I have to, you know, part of my role is to sort of you know, assess how much weight I should give the child's opinion. Because sometimes the opinion is very strongly influenced by one parent or the other, or there are other factors involved that are causing them to side with one parent or the other. So that would be dealt with in a full section 30, but not in a voice of the child, because in the voice of the child, I'm merely just reporting on what the children said.
That ties in neatly with our next subject, which is parenting and other influences. So let's talk about screening, Jonathan. Can you help us out on that one?
Yeah, so a lot of parents and lawyers and judges have concerns that if you do a voice of the child, that one or both parent will make strong efforts to influence the comments that the child makes to you. And it does happen, unfortunately. Some parents do pressure their children to say one thing or the other. You know, that's not helpful or appropriate. So things that I will look for is, you know, I'll specifically ask the children, did your mom or dad say what they wanted you to say today? What did they tell you about the process? I'll also just as we talked about before, you want to gauge the comments they make. Are they typical of a child that age and stage of development, right? So if you have a teenager who's saying, like, you know, I want a 50-50 schedule because it's not fair that my dad has to pay my mom support. You know that there's been parental influence and trying to involve the child in the legal issues. Or if it's a younger child, like we said before, and they have a very specific idea of what kind of schedule they want, it probably means parental influence, because children, young children don't have a concept of time, so they won't be able to come up with these kinds of schedules themselves. So you know that there's parental influence, or they might say other things. Like I had a child recently who said that their dad buys them cheap running shoes that only cost $1, and their mom buys them very expensive running shoes that cost $2. And so you kind of know that one or the other parent is trying to influence those kind of comments. So, there's no real foolproof way of determining exactly whether or not a child's being influenced, but with experience interviewing children and experience working in family law cases, you'll quickly get a sense of when that's happening.
Okay, let's run our next poll. And while we're giving our audience a chance to answer, I'm going to go to an audience question. So the next poll question is, at what age should the court have to consider the voice of the child? Give everybody a moment. Here's an interesting question. Who calls the clinician who prepared the report to trial if there's a dispute filed? So I'm just thinking this through. Usually you go applicant, respondent. And there's an objection filed in this particular question as well. I think a judge would probably do applicant, respondent. If the respondent is relying, then they would call the clinician, or maybe the judge would give both parties an opportunity to cross-examine the expert on the report. It would be really, the expert would be the court's witness. If you filed the objection, I don't think you have to examine the person in chief. Should be able to have a chance to cross-examine that particular expert witness. What would you say, Golan?
Yeah, so firstly, you intend to cross-examine the clinician. I think it would be the right thing to do is to file the dispute within the 30 days following receiving it. To the question of who's calling the clinician is basically the one who wants to rely on that report. Now, right. if the report is being relied on, then obviously the right to cross-examine arises at that stage. But if the parties are content and nobody's filing a dispute, it may be that the report is just being filed as an expert report that's not being challenged.
But if you don't like the recommendations and you don't file a dispute, you might have a tough time arguing later.
That's exactly right. So you want to make sure that you're not losing that opportunity by saying, I have issues with the report. I'd like to have the clinician come to court if the other side wish to rely on the report.
So let's get into some case law, but first let's see what our audience is thinking about this poll question and see what the results are. I guess the tough part of this question is, we have very mature 12-year-olds and very immature 15-year-olds, right? Every kid's different. And the court's going to need to assess that. So younger ages, not a lot, 6 to 12, 26%, 12 to 15, 34%. Clearly helpful to get the opinions of those 16 plus 2%, all of the above 31%. So bit of a variety there. Let's get into some case law, and I guess we'll start. Well, let's talk a little bit about challenging the reports. Maybe in a couple minutes or less, Golan, you could tell us about how you go about challenging these. You did mention filing the objection. What else should we need to be mindful of?
Right. So that, just touching on that topic is practically. I sometimes just firstly, if I need clarification, I will send a letter to the clinician, to find out who was in the room, for example, and whether there are notes available for review. I find that some would say to me, I don't make notes, which, by the way, Jonathan, you can comment on that. They say that they don't take notes and they just punch in they type out during the interview as opposed to taking notes and then doing the report, which I find it a bit odd in terms of practice. But so I normally try to get that first before I file the dispute. I may even ask for a critique report from a professional to tell me what's going on with or what does he find specifically, like Jonathan said, there's things that are not popping out straight from the report that we can say this is clearly influence, or this is clearly
That is a great tip. The lawyers are not social workers, and some of us are, but hire an expert to critique it and find out where the weak spots are. Good
That's
tip.
right. And I did it, I think a couple of times, even with the ones with Jonathan recently. But the point is, it gives you an insight to how the interview was conducted, the type of questions that were asked, whether it's leading questions or not. It doesn't always come out straight from reading the report. So that's the first stage that I think it's worth doing. Then the second one is, like I said, is that you actually filing the dispute report, and this is pursuant to I think it's Rule 21. Rule 21 sub E allows for filing the dispute within 30 days of receiving a report, from that would be under Section 112 of the Children Law Reform. So in that respect, you file the report, and then the last stage is, of course, challenging it in court during trial and cross-examination of the clinician, and again bringing your own expert to counter that report, or at least indicate to the judge the deficiencies or the flaws that may or may not add to the way to be given to the voice of the child in that circumstance. That's my comment on that one.
Yeah,
And I
thank
think
you.
just if I can add a couple of points to what you're saying there, Golan. For the person doing the voice of the child report, it's really important for us to remain neutral. And so if someone does have a question about your report, that's fine, but make sure both lawyers are involved in those in asking questions and providing your answer, right? Like I think, Russ, you had a case recently where the supposedly neutral professional was kind of siding with one family over the other, and was meeting with one lawyer but not the other. And I think that's not appropriate. You want to maintain not just actual neutrality, but also the perception of neutrality. And if you're just meeting with one lawyer, not the other, then you're not remaining neutral. So if a lawyer says, "Hey, I've got these questions, do you mind setting up a Zoom call to discuss them?" I'll say, absolutely. Let me loop the other lawyer into the process as well, and make sure that they're both present for that.
Good tip. Okay, let's get into the case law. Jonathan, LLVCR, what do we need to know?
I think this one's actually Golan's case.
Oh, sorry.
Right.
Go ahead.
That's okay.
Yeah. So I actually included a couple of cases here just to show the two approaches. One that said, no to a request for a voice of the child, and the other that accepted it despite one party rejecting it. This case is basically just talking about how to measure, or how to give the way to be given to a voice of the child report. And we spoke about that. It's the age, maturity, clarity, etc. All these factors that comes into play when you want to assess credibility and the way to be given to a report. So that's the purpose of that case, is just kind of touching on that aspect of how to weigh a voice of the child report and what the court is looking into when looking at the child's preferences and views that has been provided. If you go to the next slide, Shannon, I think, yes, I took in that case from the Kenape case from 2018. You can see comments from Justice Kitely. This is where the applicant was trying to say, well, if we get a voice of the child report, it may be used to influence the child to do one thing or another. We touched on that as well, because it happens that once you get the report, now you can basically either bluster your your views that this is what the child wanted all along, and now I have a stamp of approval that this is what it is, and now you kind of try to play that best you can in the process, which is the wrong way to do it. But that was a case where the judge commented that despite the fact that this is a potential risk that we take when doing the voice of the child report, in this case, it was not concerned with that. He said that the parties are pretty much amicable. There were the consequences were such that they said that the parents enjoy a wonderful relationship with their children. So there was no real concern of abusing the report, and therefore a judge approved the accepting and obtaining a voice of the child in this case. If you go to in contrast, if you go to the next case, in that case from the 2019 event, you would see that Justice Shore indicated that even though we're talking about a 15-year-old that could have given his views and preferences, but he didn't want to participate. He didn't want to go to. He did not want to be involved in that process. And this is where a judge indicated that in the circumstances, it's not going to make it. Is not going to force it. So basically he's saying no to a voice of the child report in this case, just to show you that it's not a must. It's not something that is it must be there. Now, on top of that, I just want to add, because I touched on that before when I said that there was a case that relate to abduction where the voice of the child was sought. And it actually covers two situations. It actually tells you that the Office of the Children Lawyer declined to take the case. This was an abduction case of a child that was taken from Poland and brought into Canada, and the father started an application under the Hague Convention to return the child to Poland. And the citation, I'm just going to say, so this is Stefanska and Chizinski. Stefanska and Chizinski, and the citation is 2020 ONS 3048. I repeat, that's the 2020 ONSC 3048. And in this case, Justice Hawkins indicated that, and I mentioned that the report that was taken by a lawyer who was not a family lawyer, he was not practicing in the area of obtaining reports from the children, but nevertheless,
Was it just some guy walking by and they say, "Hey, come in this office and talk to this kid," or what?
No. Once it looks like, according to if you read the judgment, it looks like once the OCL declined, the mother who wanted to keep the children in Canada went to a lawyer who was a criminal lawyer and basically asked for him to interview the child. What the lawyer did was actually fair, because he was inviting the both parents to come in for an intake. But once the father declined, then he did not do the intake with either, and he just went straight to get the to the interview and obtain the views and preferences from the child, and the judge accepted that. He accepted that as as opposed to rejecting it and saying he's not a professional, he should not have taken it in the first place. But just to show you that it's there's no hard and fast rule about it. It just, like we said, it's a preference, and we always want to defer to professionals and experts in the field. But that was
okay. Jonathan, you got the next two cases, 2 minutes or less. What we need to know.
Well, basically, both cases talked about expert opinion and how well, in this Sortie versus Sortie, they had an expert critique Section 30 assessment, and the judge rejected that critique, saying that that if the opposing lawyer wanted to challenge the report, they could do that in cross, and that the court wouldn't accept a competing assessment by another professional.
Okay, waiting for the
And
next
this
slide.
one was talking about admissibility of expert evidence. In this case, the one side argued that because a person committed a sexual offense against a child, that they were automatically a psychopath, and the judge or the court rejected that opinion, saying that there's no one profile that fits every single sexual offender. So, yeah.
All right, let's move into Q&A. We're almost at the top of the hour. Thank you so much, Jonathan and Golan. And Shannon magically appears. Welcome back.
Thank you. And thank you again to Jonathan, Golan, and Russ for sharing insights on this topic. I know you've answered a lot of questions throughout the presentation, but we have a few more here that we'll try and get through for the last few minutes. So first question I have is, will interviewing the children really help a judge decide on custody and access issues?
Absolutely. Firstly, absolutely. I mean, that's part of the purpose of getting the views and preference of a child. And again, depending on the age, depending on the maturity level, if when a kid is able to actually present his opinion or his preference, why he should be here and not there, or should be with both, because he's going to soccer practice with dad, or he wants to be with mom when she's taking him somewhere else. All of that definitely helps the court in assessing what's in the best interest and what would be best in terms of scheduling and parenting scheduling for the kid. So
and the judge is going to take a holistic view of all the evidence, and maybe the child's views will match up with other things that the judge is going to act on. Great question, Shannon. What else you got for us?
So next is a two-part question. So at what age is a child allowed to decide with which parent she wants to live, and what procedure best to follow, and any recommendations for a child psychologist helping child with custody situation?
Okay, we'll do the recommendations in the show notes, but Jonathan, 30 seconds or less, can you crack that one?
Yeah, so just a caution that if you're going to refer the child to a psychologist or another mental health professional, and they're going to be involved in a voice of the child, you want to make sure that they have expertise working in family law, because most psychologists don't, and they might actually make the situation worse because they're not aware of how to do this process effectively.
All right.
Great, thank you, Jonathan. I think we have time for one last question. So if a judge orders to complete an OCL application and the opposing party does not fill out, what consequences may follow not only to the OCL involvement, but to the opposing party, if any?
Things are going to go badly. You got to fill the form out. You can be in contempt of court, potentially. You get an order directing them to fill out the form. It's going to delay the process. And the judge may treat it like a Rule 23 hearing and say, this is now a default hearing. You haven't participated. It's like not filing an answer. That would be my take. What do you think, Golan?
Well, I think you're correct, but I think it's really just a bad inference. It doesn't prevent the professionals from actually doing the interview. So in the voice of the child with the OCL, you have to complete it within a day. So it's really pressing. Like within a day, you have to complete your intake, and then the OCL can definitely continue on that with the one intake that they have. Or they might say, we don't have enough and we cannot proceed with that. And that comes back to the judge, and that would be the consequences that you just mentioned there, Russ. But yeah,
I think you'd have to question whether that parent's acting in their child's best interest by not sending in the form. It might be 7 days. I don't know if it's a day, but that brings us to the top of the hour. Thank you so much, Golan, Jonathan, Shannon.
Thank you, guys.
all
Yes,
yours
thanks
again.
again.
Thanks for having us.
Thank you.
Always a pleasure.